Tribunal in the matter of Ronald Wyatt and Fareham Borough Council, part heard.
Yes, Mr Mould.
My Lord, there are, I think, 3 documents on your Lordship's desks.
Right.
The first is an extract from the Natural Environment and Rural Communities Act 2006, which I'll come to in a moment. The second is the case of A and Secretary of State, which is one of the 2 cases to which my Lord referred yesterday, and I think the one that is of most assistance.
Yes.
And thirdly, I've, in the interest of trying to ensure that I hit the mark, I've reduced my remaining submissions to a skeletal note, try and speed things along.
Right, well, thank you very much for that. Do you want us to read that before you start? Or?
No, I'd prefer, if it's convenient to you, to go to take you through it, but where I've given page references and so forth, I may suggest we can move fairly swiftly, but obviously not at the expense of making good my points.
You're, just to remind ourselves, and I haven't, I'm afraid, revisited the timetable, your time runs until
11.
11, yeah.
Yes. Okay. Mr. Elvin is the source of the 2 other documents, and I'll touch on those. I suspect he may say a little more about them than I do.
Okay. Yeah. Thank you.
And my Lord, if necessary, as a result of any questions from your Lordships, I'm content for Mr. Mole to eat into my time and take less time if that proves necessary.
Yes. Well, that's fine. I mean, your global time is the 3 hours. I think that was agreed. Yes. Fine. Thank you. That's fine. If you want to split the time differently so that we result in 3 hours, that's fine.
I'm grateful for that. I certainly am aiming to finish as close to 11 as I can. So first, I'm going to cover 4 or 5 topics. Firstly, just to complete the analysis on the legal framework. Can we just take the 2006 Act extract? Yeah. I draw attention to section 2 on the 2nd page, headed General Purpose, subsection 1, which states Natural England's general purpose. 2A expands a little on that. And I also draw attention to 4, advice, in particular subsection 4B. And Mr. Elvin may point you to other aspects, but certainly those provisions taken together provide, on the face of it, a statutory basis for the promulgation of the Natural England advice that's before the court in this case. Yeah.
Was the advice we've got given at the request of the public authority?
No, I think not. There was a degree of collaboration in its production for obvious reasons, because it was designed to assist in the development management process. But I draw attention to 4B in particular because Mr. Elvin will help you with this. But as I understand it, if one is to seek to root the advice in either 4A or 4B, it's better rooted on the facts in 4B. Yeah.
Yeah. Thank you.
A and the Secretary of State, the head note, and in particular the reference to the 3 types of case where a policy might be found to be unlawful at common law by reason of what it said or omitted to say about the law when giving guidance for others. They are then conveniently identified by the Roman numerals in the head note. Yeah. The relevant paragraphs in the judgment of Lord Sales and Lord Burnett, paragraphs 46 and 47, which essentially what they say about the legal position is accurately encapsulated in the head note. Again, Mr. Elvin may take you to those in a little more detail.
Yes, can I just flag up paragraph 38?
Yes.
I don't want to take time on it now because you have limited time, but I just wanted people to be aware that I've got paragraph 38 in my mind at least.
Yes.
Mr. Elvin may want to make submissions about it.
That, as I understand it, is essentially the theme that Mr. Justice Jay was seeking to express in paragraph 37 of his judgment. Your Lordships may just want to remind themselves of that, page 109 in the core bundle.
Sorry, say that again.
Paragraph 37 of Mr. Justice Jay's judgment is page 109 in the core bundle.
Yeah. Yes.
And I make it clear, neither I nor that Mr. Justice Jay said was common ground, and I make it clear it remains common ground. Neither I nor Mr. Elvin are seeking to resile from that.
Thank you.
So far as the three sort of judicial categories of which are identified in the head note and in paragraph 46 of A is concerned, this isn't a category 1 or 2 case by any stretch of the imagination, but it's fair to say it might, on Mr. Jones's argument, fall within the ambit of 3. Although it's not my understanding that his case is that the advice specifically misstates the legal position, and nor that it is misleading by omission.
Well, if I may say so, Mr. Moll, this is why I've raised this, and I apologise if it's a red herring, but it is certainly in my mind as potentially relevant to the issues in the present appeal.
But not at all.
Because sometimes, I don't say this critically at all, but sometimes phrases have been used, such as, the advice is apt to mislead. Well, that may be or may not be right. Not sure myself that that's the correct legal test.
No. If the advice, taking Mr. Justice Jay's approach, if it induces a legal error by effectively encouraging the decision maker in a given case to take a course that, if taken, would result inexorably in legal error, then category 3 in the A analysis would be engaged. Our submission is that that isn't this case, for the reasons I summarise in paragraph 4 of the note. But the principle is there, and my reference to a false dichotomy in 3 is that it occurred to me when I reflected on what I'd said in answer to your Lordship's question yesterday, that in drawing the distinction between policy and guidance or advice, I might be taken to imply that whereas policy at common law is subject to judicial intervention on the grounds in A, that didn't apply to guidance. It was somehow immune or less open to. I wasn't, for the avoidance of doubt, I wasn't seeking to set up that false dichotomy at all. If this advice is found to inexorably to lead to legal error in the way that I've just characterised, or as Mr. Justice Jay put it more clearly in 37, then plainly the court is on public law principle, the court can and should intervene.
Yes, well, certainly speaking for myself, Mr. Mould, that clarification I find very helpful.
I'm obliged. And so then 4 of my note, I've given references. It's my submission that the advice is firmly and explicitly founded upon the 2017 regulations, and it draws out key principles which are correct in law: the need to take a precautionary approach, the importance of achieving scientific certainty, and the need for individual assessment. Indeed, the stated purpose of the nutrient neutrality methodology, as set out in paragraphs 1.2 and 1.3, is to that effect. And I draw your attention to the judge's characterisation of paragraphs 4.6 to 4.9, which you looked at yesterday as impeccable. And it's my submission with respect that he was correct in characterising it in that way. The critical point being that ultimately it leaves over the judgment of the performance of any individual scheme against the statutory considerations and the test that is laid down by Regulation 63, leaves over that judgment to individual assessment and to the decision-making function of the competent authority.
And that, you say, is inherent in the guidance?
Inherent in the guidance. And indeed, one might say it is essentially, it is almost explicit if not entirely explicit, in those paragraphs that I have drawn to your attention. But inherent is good enough. I just touch on Dutch nitrogen to remind you that Mr. Justice Jay analysed that case in his judgment, and I draw attention particularly to the preamble to his recitation of certain passages, including that which you were looking at yesterday, 101, at paragraph 33, where he characterises that case as being as not addressing an issue that arises in the instant case. I explained yesterday why, in my submission, that is correct, and also that it does not seek to interfere with well-established principles, particularly, for example, that stated in the Waddensay case and relied upon by the Supreme Court. See the judgment of Lord Carnworth at paragraph 41 of Champion.
Thank you.
If I may then turn to, just to complete my submissions in relation to ground one, two more references to add to those I gave you yesterday in relation to the advice given by Natural England. Firstly, returning to the 18th of August advice, that's in the supplementary bundle at 72. In my submission, the court it will, in addition to what is said at the bottom of that page, the court is also assisted, particularly I have in mind my Lord Justice Mayle's question to me, as to what did Natural England know. The court is also assisted by the first three paragraphs of that email, which give a clearer picture of what it was that Natural England had before them, as it were. And the assessment to which Rachel Jones referred in those paragraphs, Mr. Jones showed you it briefly yesterday. That's the habitats regulation assessment at tab 22, beginning at 253. Mr. Jones showed you helpfully what is said at 269 under the subheading relating to the Solent special protection areas and so forth.
Should we look at that?
Just to remind yourself, you saw it yesterday, if we just pass over that briefly. And the key point is it refers to the adjusted nitrogen budget calculations. But the thing you haven't seen, I think, and which I do draw to your attention, is pages 270 and 271 under the heading Stage 4, summary of the appropriate assessment to be carried out by the competent authority of the local planning authority in liaison with Natural England. And you see the name of the Natural England officer is set out, is stated at the bottom of the page. And my lords, the two final paragraphs on page 270, the first two paragraphs on 271, and then everything under the heading deterioration of the water environment on 271. All of that is advice from Natural England relating to the specific scheme and the specific assessment carried out by the local planning authority. And all that taken together with what the references I gave you yesterday, I submit make it clear, demonstrable that Natural England's advice, if you like, giving a clean bill of health to the appropriate assessment and the application of the nutrient neutrality methodology in the advice note to this case was founded on an acceptance that it was appropriate to deploy 2.4 as the occupancy rate. Had there been any concern about that, the level of detailed analysis that is set out in these documents, it is inconceivable that the officer would not have raised it. That is to say, the Natural England officer would not have raised it. May we turn back to the officer's report? I have, forgive me for stating what is legally obvious, but the court will, of course, read the report as a whole. That is the conventional approach to review. I draw attention, I hope I can take this quickly without impeding understanding. I draw attention on the second page of my note to a number of references. Firstly, in the introduction, paragraphs 1, 2 to 1, 3 on page 220, refer the committee to the Dutch nitrogen case and make some points which in my submission are correct. Secondly, at 1.4 on 221, a reference specifically to Natural England's concerns about the impact of increased nitrate in relation to new development within the borough and within the catchment, and to the advice in the advice note. 1.6 and 3.2 on page 222 provide an accurate summary of the developer's response and to the mitigation that is proposed. At 226, as I showed you yesterday, we have an accurate summary of Natural England's advice. Section D, Mr. Jones drew this to your attention. Section D, beginning on page 232, continuing to page 238, paragraph 851, provides a detailed analysis of the performance of the scheme and appropriate assessment and the mitigation proposed against the legal framework of Regulation 63. And you see that that was its purpose at 8.26, where that is expressly identified as the relevant legislative function that is here being considered. 827 refers to the appropriate assessment. 832 all the way through to 850 is concerned specifically with the question of nitrate pollution and the application of the neutrality methodology. And that section deals with those issues that had been raised through the process of representation and by Natural England, also by objectors, including the applicants, the claimants rather. And in particular, you'll see at 235 issues relating to the correct values to be applied to account for the nutrient generated by the nitrogen generated by existing land uses, and as you've seen and as you're familiar with, the issue of occupancy rate at 236. I just mentioned at Roman 8 on my note that page 235 addressed the concerns raised by objectors, which were not to do with the application of average values, i.e. in the application of the guidance given by Natural England based on the farm scope and model values, but rather to do with the factual question as to what the land in its constituent parts had in fact been used for and was likely to be used for in the event that the proposed development was not accepted. And so I say that that was the issue that was before the council for consideration. It was the basis for ground 2 in the court below. It was rejected by Mr Justice J, and there's no appeal against that. Turning then to the occupancy rate issue, and may I just summarise my submissions in relation to that. Page 236. Roman 10 on my note, and 8.38 in my submission is a correct short summary of paragraphs 4.18 and 4.19 of the Natural England Advice. I don't need to take you back to that now because you're familiar with it. The first sentence is dealing with paragraph 4.18 and the second sentence is dealing with 4.19. .39 is an accurate short summary of the case put forward by objectors for a higher occupancy rate. You saw the representations yesterday. I don't need to take you back to them. 840 to 42 set out the planning officer's reasons in advising the committee for adopting 2.4 as advised by Natural England in 4.18. Having considered the case for the higher rate argued for by the objectors, I've sought to summarise those reasons in my note. Firstly, the likely variation in levels of occupancy, C 840, first two sentences. Secondly, the fact that the 2.4 figure is an average based on a well-evidenced source and shown to be consistent. That is stated in paragraph 4.18 of the Natural England Advice. Thirdly, it is precautionary. This is 841. Precautionary, as it assumes that every occupant is a new resident. I'm going to come to that in a minute. And fourthly, the application, the presence of the precautionary buffer, and then the overall judgment of 842. There's no specific justification for a higher rate.
Just to remind us, is that the language of the advice note itself?
Specific justification, yes. 4.19. Is there evidence to support the application of a bespoke, I think, or a bespoke rate? Dealing with the two factors that have been the source of most controversy in 841, firstly, what's been termed the in-migration assumption. We know now that the planning officer's statement in the first sentence of that paragraph was correct. See Miss Potts' evidence, second witness statement in paragraph 31, and I give you the reference for that. But in my submission, on analysis, the Natural England Advice reveals that assumption. It may be helpful just to have that open in front of us. It's page 11 in this bundle.
Yes, just a second. Yes.
The first sentence of paragraph 4.18 distinguishes between increases in housing stock and increases in population in the catchment. Paragraph 4.18 assumes that each additional house will result in a net addition to population within the catchment. No allowance is made for occupiers decanting from existing housing within the catchment.
Just pausing on that for a second. I mean, at first blush, one might say, mightn't one, that if you're adding to the housing stock by 8 houses, be it 8 houses, 80 or 800, you're adding to the housing stock in Fareham.
Yes.
And it's a reasonable assumption, one might suggest, to assume that, I suppose one could say sooner or later, all of those dwellings will be occupied. So there will be, through the development, an increment in population attributable to the development.
I agree with that.
So why wouldn't that just be, as it were, normal and obvious? Is this to do actually with the time it takes for this, if you like, churn, if that's not the wrong expression, to take effect? And the, as it were, the worst case assumption made here is that the churn is instantaneous. Is that really the point?
That is also implicit in this, but there is the related point I'm focusing on is that it is fanciful to suggest, other than a proportion of new housing stock provided in Fareham will not be occupied once it is completed for occupation or at a later date, only by those who are new to Fareham. For example, there may be households in Fareham where, which are occupied by a number of residents, and of those that occupy that existing housing, some will take the opportunity to move out of that household.
But why does it matter whether they're present residents of Fareham? Surely this is just about the number of people who live in Fareham.
Well, it goes to the overall net increase, scale of net increase in wastewater that is generated, because it is occupation that generates the wastewater.
Of course,
not the presence of the.
I'm sorry, forgive me, but why does it matter whether they already live in Fareham? I mean, if there are more the layman might say if there are more houses, there are more people. It doesn't matter where they come from. They are people, and they're generating nitrates in the runoff.
If they're already generating nitrate because they already live in Fareham and they simply move to another part of.
Well, then somebody else comes to where they live.
Well, they may not, because of course, take for example the obvious example of a household where at present parents and grown-up children live together, and the opportunity is taken to take up occupation. The children move out when a house becomes available to them, or the parents move out and leave the children. That is a perfectly standard and normal state of affairs. After all, one of the key pressures on housing stock in this country, one of the consequences of the pressure on housing stock in this country is that adults are having to live with their parents for much longer than they would choose to do so. So one can see that's an example of that. The reason why this matters is precisely because there is already a level of pressure on wastewater management within the catchment. And what this guidance is seeking to do is to identify the increase, the net increase that is likely to flow, to result from new housing. That's why the distinction is drawn between the bricks and mortar itself and the people who occupy it.
Are you saying that what one is actually interested in, because of the underlying rationale of what the concern is, what one is interested in is net increase in population of the catchment area?
Exactly.
Not net increase in housing stock, for example.
Exactly. That's the critical point that is made in the first sentence of paragraph 418.
One needs to focus on population.
Yeah.
And there are, as it were, demographic factors at work in this. We've mentioned one, there may be others.
Because whilst the houses are void, it's essentially not generating.
Well, that's another factor. I mean, that's the temporal factor.
But that's a way of illustrating the distinction between the stock and those who occupy.
Yes.
And so there is, leaving aside that Miss Potts explains that.
I'll deal with it.
But I'm seeking to add a measure of robustness to my response, which is, as your lordship said yesterday, if we look at this only through the lens of what the planning officer reported, was that first sentence of paragraph 841, I think it was.
Yes.
Was that a reason that was open to him?
Yeah.
My lord asked the question: was it in conflict with the Natural England's advice? I'm seeking to show that far from it. It was entirely consistent with the logic of 4.18, and it was also the in-migration assumption, if you like, was evident from 4.18 once one reads it carefully. And the reason why it mattered, why it was sensible and reasonable that 418 should be drawn on that basis, on that clear distinction between bricks and mortar and occupiers, is because it's the occupiers who give rise to the wastewater. So there was an assumption of a net increase, if you like, in wastewater, notwithstanding that some of those generating the wastewater in the new properties, once they came to be occupied, would already be generating wastewater because they'd already live in the catchment. That's the point.
Yeah.
And then on the double counting point,
Yeah.
my submission is that on a fair reading of the second part of that paragraph of it, what the officer is simply doing is saying, if there is, on this issue, as there appears to be controversy about whether the use of the 2.4 is sufficiently precautionary, we do know that the precautionary buffer is intended to give a further measure of reassurance. And that was a position that was reasonably, in the legal sense, open to him. It involved no conflict in my submission.
Well, the proposition in a biblical image was that Peter was being robbed to pay Paul.
Yes.
And that's what perhaps one might expect you squarely to confront. Is Peter here being expected?
No, Peter makes his goods available to Paul to use in order to add a measure of robustness to his analysis, and that is clear from paragraph from what the guidance says at paragraph 4.67 on page 21.
Well, then the other point is the double counting point, which is the way you introduced this just now. It's an observation or a question that I asked yesterday that comes back to mind, which is that one might understand why it's done once, but if it were done a second time, then that might be using it twice illegitimately. But is the precautionary buffer then, as it were, prayed in aid somewhere else in the analysis that might cast doubt on the integrity, if you like, of this analysis at 841?
The precautionary buffer was applied to the positive nutrient budget calculation.
Yeah, 4.67.
Yes. Sorry,
Mr.
You were asking me about this case.
Yes.
In this particular case, the figure that the planning officer speaks to, which you have at page 235 at the bottom of page 8.37. That is to say, the 10.5 kilograms, which is then mitigated by a wetland scheme that generates 11
Give us the reference again. I'm so sorry.
235, page 235 in the supplementary bundle.
Yeah.
Paragraph 8.37. You see the adjusted additional nitrogen yield that has to be mitigated. It was on the adjusted figure. It was 10.5 kilograms. And if you remember, the mitigation scheme was assessed to provide a reduction of 11.51 kilograms. That was 237, page 8, paragraph 847. So that was the balance. We need to provide mitigation to cover at least 10.5 kilograms of additional discharge. We are doing that by providing a wetland mitigation, which will generate at least, on our analysis, 11.5.
So it follows, does
capacity.
it, from that answer that 841 in the committee report does not represent, in this instance, any element of double counting?
No, I don't want to. I want to make sure I'm answering your lordship's question accurately.
Yeah.
That figure is the product of applying, amongst other things, the 20% precautionary buffer. So the calculation proceeded in this way. At the first stage, the occupancy rate of 2.4 was deployed, and part of the justification for that was the existence of the precautionary buffer. At the final stage, the 20% precautionary buffer was applied. The question is whether that amounts to double counting. There was no arithmetical adjustment to the 2.4 at that stage in the analysis.
No.
So if there is double counting, it is in the sense that one sees in paragraph 8.47 41, that is to say, the planning officer invoked the existence of the precautionary buffer, which would be applied at a later stage in the calculation, as adding a measure of precautionary reassurance to the deployment of 2.4 as the appropriate occupancy rate. Yeah. That is the way in which it worked. Yeah. The complaint is that that is contrary to the methodology, because the buffer is intended to operate in addition to the deployment of a precautionary occupancy rate, and that you should not infect the latter judgment with the former. That's the complaint, as I understand it. I say that that is too hard-edged an approach. One has to remember that the purpose of the buffer is to provide an overall measure of reassurance to the analysis, recognizing that each of the earlier stages involves an element of uncertainty and an element of judgment. And so it is entirely intellectually acceptable and entirely consistent with the reasonable and proper application of the guidance to rely in part upon the existence of the buffer to justify the deployment of the occupancy rate that is selected.
That seems to be the approach in 843, dealing with the figure of 110 litres per person per day, where they say they think that's a reasonable figure.
Yes.
But there is also the buffer.
Exactly, yes. My Lord, absolutely. I respectfully agree with that.
Does this all lead ultimately to the point that was canvassed yesterday at some stage, that the whole thing is ultimately a holistic exercise through which judgment necessarily runs, as it were, at the appropriate stages, and that one has to look at the ultimate conclusion of that holistic assessment to judge whether it was commensurate with the legislative requirement.
That's the burden of my submission, and it is with that thought in mind that I have emphasised, I hope not unreasonably, the absence of any concern on the part of Natural England in approaching the matter in this way. Natural England, if Natural England had felt that the advice was being misapplied by deploying 2.4 and then the buffer in the way that it's been done here, no doubt that would have been a point that would have been raised as a matter of concern. After all, we know that Miss Hunter didn't shrink from raising points that she said needed to be addressed when that was her judgment. She raised the issue of existing land use. She raised the issue of site areas. She held no brief, if you will, for the development. Her task was to make sure that, as we see from the 2006 Act, that the general purpose of advancing the interests of the natural environment was fulfilled. And I draw attention to 4.67, which actually explains the function of the buffer. Page 21 of the supplementary bundle. My note at the top of page 3. I won't read it out, but your lordships will have read it. 4.67 is relevant here.
Yes.
That supports your lordship's holistic characterisation of the exercise as a holistic one, and of course evaluative.
And at the risk of stating the obvious, that's where the figure of 20% comes from. It's you submit. This is an expert body which has recommended that figure. It's not just somebody sticking their finger up in the air.
No. I with respect, my submission, I think I set it out in writing, was that in relation to ground 3 of this appeal, was that the notion that qualitative judgments of that kind, founded upon an understanding and a reading of the relevant literature, which I think is the way in which it's put by Mrs. Potts, suggests that that is somehow inadmissible, is in my submission, a very difficult argument to sustain.
Or even if it is a question of sticking a finger in the air, it's natural England's finger which matters.
And it's an expert finger. Yeah.
Exactly.
Mrs. Potts is very relieved to hear.
It's a dexterous digit, yes. Yes, indeed so. There's also helpfully a worked example on 22, which, as it were, sets out in fairly straightforward terms the whole process in a single page, and you can see the application of the buffer at 4. I mean, that illustrates the holistic nature of this exercise.
Mr. Mould, can I think you're about to leave round 1. But
yes.
Before you do so, can I ask you about a scenario which I've been reflecting on? Because yesterday I think you made a submission about the need for consistency in decision making by planning authorities. And I was wondering how, at the conceptual level, I'm not looking for evidence or facts, but I want to understand what your submission is as a matter of law on how could a local planning authority lawfully deal with, let's say, an application for planning permission for housing development. And to make the figures easy, let's say it's 100 units, but they're all one-bedroom units. In that situation, can the lawful planning authority lawfully say, well, we know that the occupancy unit, the occupancy rate in practice may be 1 or 2 people, but we're going to take the national average of 2.4, because that's been recommended to us as a starting point at least. In natural England, we don't think that there's a specific justification for taking a bespoke approach on this occasion. I mean, what would your submission be in that situation? Could they properly do that?
They could. Firstly, because I mean, on the premise that the guidance given by Natural England on that question is itself not irredeemably unlawful, which is, I think, the premise for the question. They could do so. Firstly, because that was the advice of Natural England, and they would, as we saw, Regulation 63.3, they are required to consider that, and they are required to give it weight. See Smythe. Secondly, it would be an example, perhaps others, the developer might say excessively, but an example of a highly precautionary approach. Thirdly, we know from the evidence of Miss Potts, which might or might not be available to them, that the actual wastewater generated by small units taken in aggregate is at the higher end of the scale, as it were. There's a non-linear relationship between the size of the unit and the level of discharge, which proceeds from the high end is the small unit to the.
Well, the graph would be a downward curve.
Downward curve, exactly. But it would always be open, see paragraph 4.19, for the developer to say, whilst, as a matter of generality and in order to secure consistency of approach across the catchment, we understand why Natural England may give the advice that they do, and there is some force in it. Here is an analysis we have carried out, which we're prepared to, if necessary, to see supported by the imposition of appropriate conditions or by some provision planning obligation if it were possible to achieve it. Here is an analysis that shows that in this case we can be confident, and you can be confident on the basis of the evidence, that the actual discharge over time in relation to this development will not approach an average of 2.4 per unit. And therefore, we shouldn't have to provide the additional wetland mitigation that you're seeking, but in fact 80% of that would be sufficient. And if the planning authority said, no, sorry, we don't accept that, then the remedy for the developer would be to appeal to the Secretary of State, and to seek to persuade the Secretary of State to take a different view. That's the analysis, both in substance and in terms of the planning procedure that governs the development management system that would govern that. And it's very difficult to see, it's not easy to see how a controversy that might arise as to whether the planning authority was being excessively precautionary, if you like, how that might be challenged directly. Because the implication of your Lordship's question is that in practice, if that dispute wasn't resolved, it would lead to the refusal of planning permission.
I mean, in the nature of things, if the complaint were excessively precautionary, that would be statutory appeal.
Exactly.
In a case such as the present, recourse available to a local resident who is aggrieved by what has been done in this aspect of the assessment is judicial review.
It is.
So the points have to be deployed in that frame.
Yes, yes.
But you come back, as I understand it, to the advice itself as it is written, which speaks ultimately about, what's the expression, a specific justification
Yes.
being isolated.
And we know, because the claimants relied on it and the planning authority accepted it in those key paragraphs, that there has been at least one instance in Fareham of a sheltered housing scheme where, for reasons that are obvious from the nature of the scheme itself, the authority was prepared in that case to accept a lower rate because it was confident that would be borne out in practice.
There's a further point, I suppose, which is, I don't know, this may be speculation, that to the extent that they haven't done that small developments, there's a degree of cushion accumulating through that. If you look at the Solent region as a whole, or even Fareham as a borough, but that, of course, is not territory for the court at all.
No, not least because there's no specific evidence in relation to the court. But it's a plausible
We must
hypothesis.
focus on whether the exercise here was one that was unlawful, having regard to the guidance that was given by Natural England and their conclusion on this proposal itself.
Yes, and I am content to rest my case ultimately on the rationality of those paragraphs, on those 4 or 5 paragraphs. Indeed, I am unable to do anything more than that because, from my perspective, that's the basis upon which the decision was made.
I don't think the phrase specific justification does appear in the advice, not in 419 anyway, although it does say needing sufficient evidence for a bespoke approach, which you may say comes to the same thing.
I accept that, but it does come to the same thing.
In substance, it's the same thing.
And lest there be any comeback on that, one of the things we do know is that it is not necessary for planning officers' reports to use the very language.
No.
Of course.
No, I led us all in that direction when I asked the question, and I didn't go back and check, so it's my fault if we're there, not anybody else's.
No. I jumped on that train.
Not always wise. Not always wise.
I'm conscious of the time, so
Yes, of course.
I must get through,
Yeah.
if I may.
I'm sorry, I hope I didn't cut across what my lord was asking.
No, not at all.
Paragraph 9 of my note, I don't need to trouble you with any development of that, nor indeed paragraph 10. I hope it was clear from our respondents' notice that we were essentially expecting to adopt what Natural England said on those points. Grounds 2 and 3, paragraph 11, my Lord Justice Singh drew our attention to ground 5 below yesterday. It essentially attacks the validity of Natural England's advice at those paragraphs that I mentioned. I do make the point that those arguments were not made by objectors to the planning authority. At least I don't detect them in the representations that you have in front of you. And I have not detected them in other materials that were before.
Right, I do have to intervene because it's not a point made in the court below, and if it was, we would have put it in. We were criticised by putting in, by Mr Justice Jay, putting in too many documents of previous representations, and there were representations going to, if we're going to get in, if this new point is going to be raised by my learned friend, as to the approach to land use. Now, I accept that Dr O'Neill's specific expert evidence and how he put it was after the decision. But it isn't right to say that my clients were not taking points relating to the approach to the land use.
Well, I don't want to cause unnecessary dispute.
No.
I'm content to take it on the basis that Maloney Friend has put in, but it doesn't dissipate the force of the response, and certainly doesn't dissipate the point that they weren't a source of concern for natural England. And I've made my submissions in paragraphs 27 to 31. This is really, insofar as these grounds have any weight, they're really, I think, best dealt with by Mr. Eldin. And so
if the arguments were made, they were not. Do we know whether they would have been shared with Natural England or not?
I'm afraid I can't help you.
Simply don't know.
No. It does seem to be does in substance appear to be an attack. Indeed, as it appeared below, to be a direct attack on the validity of the advice rather than deployment of it. After all, there is no suggestion in the report that the officer has done other than to follow the advice on those particular points. So ground floor, very, very briefly, I draw attention to the grounds of claim, which you have at the core bundle at page 357. Ground 8, as it was, as I understand it, and as I understood it, raised 2 points. They're there set out and helpfully identified as the first and second point. So those are the 2 points which form the basis for ground 4 as it is before this court. It's developed in the grounds at pages 390, 393. I notice there's a short point at 114. The first point, which is that a failure to consider and reach a conclusion on whether the proposed development was in accordance with the development plan, the first part of the section 38.6 duty. My Lord, I rely on paragraph 883 of the officer's report. It may be helpful just to turn it up. Page 244 in the supplementary bundle. And my submission is a straightforward one. On a fair reading, as Mr Justice Jay found, the planning officer's concluding advice to committee on the first stage of the section 38.6 analysis is to be found in that paragraph and in that final sentence. That was our case below. See the detailed grounds at paragraph 73, and I've given you the reference. I don't think I can develop it further. This court will judge whether it accepts that.
No, I mean the point that was developed yesterday in particular was, I think, the suggestion that the foregoing analysis in paragraph 883 was A, irrational, and B, I think A, irrational in itself, and B, incapable of rationally founding the conclusion in the final sentence of paragraph 883.
And that's what I'm seeking to respond to in 17 and 18 of the note. That, as I understand it, is the second point.
Yeah.
For the first point, it's a straightforward argument. There wasn't a finding as to whether or not the development was in accordance with the development plan. And I say that on that point, the final sentence of paragraph 883 is, on a fair reading, is that finding. And so that was the judgment of Mr Justice Jay, and I say he was correct for the reasons he gave.
If we just delve a little more deeply, though, if you go back to 881,
Yes,
where DSP 40 is being dealt with,
yes,
and the officer does in fact go through the 5 criteria.
yes.
They're not in sequence. They're not in chronological sequence exactly.
Yes.
It comes at the end to say officers have, however, found there to be some conflict with
Yes.
the second test of policy DSP 42, since the site is acknowledged to be in a sustainable location but is not adjacent to the existing urban area.
Yes.
Now, is that the extent of the conflict?
Yes.
With,
No, with the policy, that
with
policy,
with
yes.
that policy.
Yes, yes.
Which is a partial conflict with Criterion 2.
Yes.
Can you help the court with any submission that the authorities would make about the real sense of Criterion 2 and what it's driving at?
Well, I can help you with firstly by showing you the criterion itself,
Yeah.
which is which the officer set out at the bottom of page 238.
Yeah, we've got the policies.
Yeah. So the criterion, so the policy,
It says the proposal is sustainably located, adjacent to and well related to the existing urban settlement boundaries and can be well integrated with the neighbouring settlement.
yes,
So in a sense one might say, if one was a layman, well what's really the point? Why would the LPA want to be doing that, would be the question perhaps, as a layman would ask. Layperson, I should say.
and the purpose is, well, stepping back, I have sought to address this in 17 and 18 of the note, but
Yeah.
stepping back, the purpose of this policy was to enable the planning authority to manage the release of sites for housing which were not allocated in the plan and which may ordinarily be subject to constraint policies, as indeed with this site, because it lay within the countryside. To manage the release of such sites in circumstances where the council was faced with a shortfall in its housing land supply. And those who are familiar with the planning process will know that planning authorities tend to prefer to reserve the management of such release to themselves, to be dealt with in accordance with their own stated policy, rather than to be faced the prospect of having to deal with a series of appeals, where effectively the release is being governed by the Secretary of State and on the application of developers. So this policy has that purpose. It is intended to ensure, and the criteria are the mechanism whereby the planning authority manages that release in a way that is designed to draw the balance between making a contribution towards reducing the shortfall in housing supply, but in a way that doesn't give rise to unacceptable planning harm through encroachment into the countryside, environmental harm, etc., etc. Criterion 2 is essentially part of that process, and it's designed to ensure that a site that is released, an unallocated site that is released under this, in this case beyond the settlement boundary, is nevertheless located in such a way as to avoid, for example, the need to make further educational provision, because it's not well related to existing school provision within the settlement. The encouragement of an increase in the use of the private car to get to the shops, that kind of thing. That is why it focuses on sustainable location. But obviously, the well related to the existing urban settlement boundary is not only concerned with the function of the site in relation to the existing settlement, it's also in part concerned with its visual relationship. if one has new housing that is away from the existing settlement boundary, it may be seen to be unacceptable because it has an encroachment. It encroaches visually into the two undeveloped countryside. So there are a number of facets to this. And it takes its place alongside the other criteria, which are concerned firstly with the environmental and amenity impact of the candidate site being released through the medium of this policy, but also the degree to which it will make a contribution to the shortfall and the period within which it's able to be delivered, because obviously the scheme will attract more weight within the scope of this policy to achieve its intended purpose of reducing the shortfall if it can come forward quickly rather than at a longer pace. Now, what the officer did, who analysed this in considerable detail in paragraphs 8.552 to 8.72 in his report, 8.52 to 8.72, what he did was to consider the performance of this site against each of those criteria. And at 8.55 on page 239, he found the limited degree of conflict that he summarises in paragraph 8.81. And I must get on because...
yes. Well, I'm sorry, I asked you that question because it seemed to flow from the submissions we had from Mr Jones yesterday.
And so, my Lord, my submission is that the question is, did the acknowledged fact of that limited conflict vitiate the judgment that nevertheless the scheme could properly be seen as being in accordance with the plan? And for the reasons I set out in 17 and 18, particularly 18, I submit that is not the case. Ultimately, there was an element of judgment here. There was no suggestion of misinterpretation of the policy. It was accurately and properly understood and applied. And the fact of limited conflict was expressly drawn to the committee's attention, so they knew what they were faced with. And in that context, for the reasons I give in paragraph 18, I submit that the judgment was one that was open to the planning officer and for the committee to accept. Lord, forgive me for rattling through that, but...
Thank you very much, Mr. Earl. Thank you. Yes, Mr. Earl. I'm sorry, I should have asked my colleagues for the question. Mr. Earl.
May it please the court. Notwithstanding certain points that were made by my learned friend Mr Jones yesterday, we are here because our advice was attacked in the claim form, as the court has seen, in grounds 4 and 5. Ground 4 has fallen by the way. Ground 5 effectively incorporates what are grounds 1 and 3 before this court. It attacks the use of averages, which goes to grounds 1 and 2 before this court, and it attacks the use of the buffer in terms. So, my lord, we would not be here unless our advice was under attack. Can I also just add this? This case raises important issues. If my learned friend is maintaining his attack on our guidance, this has become a very hot topic in terms of environmental issues and planning in recent years, and the issue of the national guidance last month underpins the extent of the concerns. The national guidance, which is based in part on the Solent guidance and other individual guidance notes issued for a few other catchments, such as the Stodmarsh SAC around Canterbury and Ashford. This was rolled out, as we told Mr Justice Jay, it was in train at the time, and it affects 26 catchment areas around the country and 76 local authorities who are all notified. If your lordships have, I won't waste time by taking you to it, but
76 authorities.
76 authorities. If your lordships, when come to review the documents, look at Natural England's covering letter and advice note, which went out on the 16th in the additional documents I provided, there is a plan showing the extent of the catchments affected, which shows it at various points around the country. I think it's page 11 of 25 for the court to note. And of course, Natural England is is here to explain its position in the advice note to the extent that that's of assistance to the court. Natural England has no axe to grind. It simply wishes to get its advice right. And if the court considers it hasn't got its advice right, then as we've indicated in the covering letter, the national advice is provisional only and is dependent upon the views of this court in due course. But Natural England simply wishes to make sure it gives accurate advice to the local authorities.
When you say get it right and accurate, you mean as a matter of law?
As a matter of law, yes.
Which is, of course, the only function of this court.
Indeed, and I will turn to that only very briefly because the court is well aware of the principles and the learned friend has canvassed them as well. Of course, whether Regulation 63 in some way is violated by the guidance, we submit is not correct. But my learned friend's reluctance to distance himself from the proposition that it may have a much wider effect, in my respectful submission, is correct if he maintains his attack on the guidance for the reasons I've just indicated. This is an important national consideration. But his reference to the fact that there is a way out, and he referred the court to Regulation 64 and the derogation provisions and IROPI, in other words, imperative reasons of overriding public interest. That is a very difficult provision to use. I'm not aware of it having been used significantly in the decades that these provisions have been in operation. At the Dibden Bay inquiry 20 years ago, where I think I was for RSPB, the proposals for a deep water port in Southampton were rejected because of the breach of what is now Regulation 63, and Regulation 64 was held not to apply because there are two, I'm not referring to documents, it's just an explanation leading...
Well, I can give a number of where I've successfully invoked it, and I can give that, for example.
James, I've got limited time, you've got to reply, please let me continue. And the important point is that in order to establish the derogation, you have to show there are no alternatives, not simply no reasonable alternatives, but no alternatives. And that could be countrywide. So the 17 authorities of the Solent can't have new housing if they can go elsewhere in the country. Well, that may be fine from one point of view, but it scarcely deals with the issues of the need for local housing. Secondly, you've got to provide compensatory habitat. That is a real difficulty. If you're dealing with river catchments flowing into widely defined protected areas such as the Solent, how on earth can you provide compensatory habitat for such a wide-scale protected area where the very impact that's being justified is actually harming the watercourses themselves by discharging further nutrients? So there are insuperable practical problems in operating the derogation provisions. It hasn't been invoked before, and my learned friend is simply giving that as an example, but it's an example which is deeply flawed for the reasons I've indicated, because the criteria are so rigorous. If the consequence of the high hurdle of Regulation 63 is Natural England has got it wrong, then so be it, but we submit not. The court has seen that the advice is advanced as one means by which the local authorities now, on a national basis, can deal with the issue of nutrient pollution by achieving nutrient neutrality. And the guidance, as the court will have seen, emphasises on several occasions this is not a prescriptive approach, it is one means, and that phrase appears in one form or another in paragraphs 1.3, 2.2, 4.1. And as the court has seen from 418 and 419 in the advice note, the advice is given on the basis that the local authorities, it's recommended to the local authorities, that's the phrase used in 418, page 11 of the supplementary bundle, and that they may choose to take another course if it is sufficiently robust. And it is the sufficient evidence requirement that the learned friend was dealing with, and indeed, at the end of 419, the competent authority has to be able to explain clearly why the approach taken is correct. And in my respectful submission, 419, if read fairly, properly encapsulates the high standard of the test to be applied for appropriate assessments as contained in numerous judgments of the Court of Justice and endorsed by the Supreme Court in Champion, in other words, capable of removing all reasonable scientific doubt, etc. That is an accurate statement of the legal principle that they must apply in judging the evidence on the appropriate assessment.
What were your one-way references? 1.3, 4.1, and what
Sorry,
was the other
I
one?
did them too quickly, my lord.
I got 1.3 and 4.1.
2.2,
2.2, thank you.
and 4.1.
Thank you.
If I could turn to the Act, which I produced in response to my Lord's question yesterday, my learned friend is quite right. Can I draw the Court's attention to the general purposes at section 2.1 and 2.2a? That is to say, general purpose to ensure the natural environment is conserved and enhanced and managed for the benefit of present and future generations. That's obviously engaged. And specifically, the promotion of nature conservation and protecting biodiversity. So, in my respectful submission, those aspects of the general purposes are directly engaged here. The advice provision at section 4, again, I respectfully agree with my learned friend Mr Mould. This is section 4b, where
I'm
naturally...
struggling to find the Act.
I'm sorry, my
There's
lord.
a lot of paper now
I do apologise.
on the bench. For some reason that has gone to ground. Yes, here it is. I'm so sorry. Just give us the...
Sorry,
me,
Lord.
I'm sorry.
I was
The
referring to
references,
the
yeah.
purposes, the general purposes in section 2.1,
Yeah.
and the element of inclusion at 2.2a, which specifically deals with conservation and biodiversity.
Thank you.
Section 4, there is a duty to provide advice if requested to do so, and of course that was engaged here by consultation from the local authority. And subsection 4, Natural England is entitled on its own initiative to give advice, which we submit is, what the advice here is its advice under section 4.4b, sorry, 4.4b, but it's also effectively generic advice, which is part of the answer to questions asked in relation to Regulation 63 itself. And 63.3, of course, has a specific provision relating to Natural England's advice, and it goes part and parcel of the general advice. So the general advice is part and parcel of the specific advice which is given in a particular case. Also draw the Court's attention to the fact that there are it's got power to do anything incidental to its general purposes in section 13, and section 3, there is a duty to keep under review all matters relating to its general purpose. And you will have seen in the opening sections of the advice note and in Ms Potts' evidence, particularly her second witness statement, the history of this advice, which has been evolved over a number of years in consultation with other public bodies. And indeed it's entitled, and it's required to consult bodies when it's reviewing, and it's also entitled to undertake research or commission or support research. That lies behind the farm scoper average when you come to the averages. When you come to that, that was in response to a research commissioned by Natural England from ADAS, and that's referred to in the advice note. My Lord, I am in the same position as my learned friend Mr Mould with regard to the application of the judgments of Lord Sales and Lord Burnett in A and the Home Secretary.
Yeah.
This is not policy in the classic sense of guiding how you might exercise your discretion. Indeed, it's rather more focused. It's advice as to how you might go about dealing with a specific issue in the context of the statutory duty that competent authorities have under Regulation 63. But there's a distinction without a difference, because in my respectful submission, it's absolutely right to concede that it must fulfil the Gillick principles as summarised by Lord Sales and Lord Burnett at paragraphs 46 and 47. And indeed, I respectfully accept the point in paragraph 38, because that's part and parcel of what feeds into paragraph 46. Public authorities have a general duty not to induce violations of the law by others. The last thing Natural England wishes to do is to do that. It is seeking to try and find a way through the difficulties, not creating more.
Yes, just to be absolutely clear, Mr Alvin, the legal significance of the judgment in A is that before last year, when the Supreme Court authoritatively and clearly set out the position, there had been a number of decisions of the courts, including certainly at this level, where policies and similar sorts of guidance documents had been challenged on the ground that they create a serious risk of something, for example. And what's been made absolutely clear, as I understand it, by the Supreme Court, is that that is not the test. It's not things
It's
like...
one step further back from that.
Yeah, well, does the policy in question authorise or approve unlawful conduct?
Indeed.
By those to whom it is directed. So that's why, with respect, I have suggested at this hearing that phrases like, oh, the policy is apt to mislead,
Isn't sufficient.
isn't sufficient.
I respectfully endorse that, my Lord. And at first instance, I wasn't aware that Mr. Jones was making the submissions in those senses, and which is why we conceded that if Natural England had given advice which was unlawful and that had induced an error by the authority, i.e. meeting this higher test rather than simply being apt to mislead, that it would be a basis for quashing the decision. And you see that concession recorded by Mr. Justice Jay. And indeed, he'd said something similar in the Wilden case. And in my respectful submission, Mr. Justice Jay didn't, I think, trespass into the broader area of it may mislead. He took it in a way which is now reflected in it.
So subject to anything said in reply, that's how I read it. As well.
Indeed, my Lord. And my Lords, I also just point to paragraph 47 in that one doesn't need to go into full detail. It needs to be, it would make it unwieldy and difficult, providing it sets out with clarity the principles, and we say that that is the case in this instance. And, Lords, that's where I really come to my primary point, which is embodied in the respondent's notice as well, where, and my complaint about the attack on Natural England's guidance, and a limited complaint with regard to Mr. Justice Jay, is picking out the statistic for occupancy rates and viewing it in isolation. It's the point about the holistic methodology. It is the methodology as a whole which is advanced, not just part of it, as a whole which is advanced as a suitable means with all the caveats given in the advice about needing to check things in certain cases, which is what we submit is the appropriate approach to appropriate assessment.
Yes. I apprehend that the answer that might be given on the other side to that submission might be that that's all very well. It may be a holistic assessment ultimately, but that should not prevent one focusing on
A component.
A flawed component of the assessment, which serves to vitiate the whole thing. And it's one. The court must not be distracted into regarding it as some sort of global exercise, which doesn't admit of any intrusion of scrutiny into the individual elements of it, I think is the point.
My Lord, and I'm about to address that.
Yeah.
The difficulty, and this difficulty stems from Dr. O'Neill's evidence, which was responded to by Mrs. Potts' third witness statement. It hadn't been produced at the time of her second one. Was that it just looks at the statistic. And as Mrs. Potts explains, and as you see from the guidance itself, though in less detail inevitably, the occupancy rate is being used for a particular purpose. What needs to be established is the amount of wastewater being put back into the system, which may reach the protected waters. All of this is a proxy for reaching the amount of wastewater. Can I show you that in the guidance? Because it's actually said in those terms. If supplementary bundle pages 11 and 12.
Yes.
And what my learned friend's submissions ignore, and with respect to him, Mr. Justice Jay wrongly simply focused on one element and saying it wasn't best evidence. The stage 1 applies the occupancy rate to calculate the scale of water usage, which is 420, and then 423, water usage is a proxy for the amount of wastewater that is generated, and you'll see that a worst case position is being adopted. New residential development may be able to achieve tighter water use figures, and says, well, there may be a basis for using the target of 100 litres. But it goes on to say there's concern about establishing certainty in this over time, and standards may slip. So it recommends the higher assumption of 110 litres per person per day. Recognising that there may be scope to improve on that, but to take a precautionary approach, you are taking a worst case position. Similarly, when you come to look at the intervention of the wastewater treatment works, and you get to 428, it is assumed they are operating at 90% of permitted limit. In other words, they have little scope to take further wastewater and process it. So again, a highly precautionary worst case scenario. Indeed, as Ms Potts said, they're actually operating well within capacity. I think something like 25% capacity figure is available, but it's assumed in order to be suitably precautionary, given that factors may fluctuate over the lifetime of the housing, and you're looking at a position of 80 to 120 years, I assume, for housing. Similarly, you then have a relationship between total nitrogen and water usage. It again goes through, I'm not going to read them out, but it goes through a series of precautionary steps. It also notes household water forms a relatively small proportion. There may be substantial reductions in drinking water, in discharges in relation to drinking water. Then it deals with nitrates and nutrients that are there naturally, but that's approached with caution, as you'd expect. So the whole exercise is to try and establish how much wastewater actually gets into the system. And if I can reiterate what Mr Mould has said, the point about migration, and I know it was exercising my Lord Justice Mayles yesterday, because it doesn't actually state it in terms. It's stated by its absence because there's no discount suggested. And Mrs Potts explains why. Precisely the points that my Lord, the Senior President, was putting to Mr Mould, that is, it is difficult to know precisely what discount should be applied in the churn. Can I take you briefly to Mrs Potts on that? Mrs Potts, Witness Statement 3, tab 13 of the supplementary bundle, page 125, well, 124, going over to 125.
Sorry, tab 12, I think. Tab
11.
11, yeah.
11, yeah.
So
124 going over to 125.
Yeah.
And you'll see, she says at the top of 125, it's acknowledged understanding migration in any given area is very difficult. So embedding 100% inward migration assumption represents a significant safeguard. And in fact, there are other elements of precaution built into this as well, and they're helpfully summarised if the court would go to her second witness statement. Tab 16, 175 to 176, she puts in a table which summarises them.
I'm sorry, where are you now?
175 of the supplementary bundle, Mrs Potts' second witness statement, which was produced before Dr O'Neill served his, in response to the grounds in the document. And you'll see it lists a number of precautions, we would say worst case assumptions built into the methodology. Now, the 2.4, it's also important to understand a number of things. Firstly, it actually equates to the local averages. If in response to Dr O'Neill's point about this, if the court would go back to witness statement 3, page 123, and she refers to the Fareham occupancy rates. She deals with that in more detail. I'm sorry, I'm slightly dotting around. You'll find then the details of that back in witness statement 2, paragraphs 19 to 22, pages 164 to 165. It's the average occupancy rate. It isn't the average for 4 to 5 bedroom houses, and she explains why. In part because you have a non-linear relationship, as Mr Mould has mentioned, between water usage and the size of household. Presumably it's down to things like if you've got 4 people living in a house, you don't need to do, you still do the same amount of laundry or run the washing machine the same number of times, or when you're cooking meals or washing dishes, that sort of thing. There are economies of scale which are applicable to larger households which don't apply to the smaller ones. If you have to set the washing machine running, you may use the same amount of water doing the wash whether you've got 2 people or 3 people. Sorry, I'm not trying to be anecdotal about this, but I suggest
it's always good to be educated on these things, Mr. Phil.
I'm not going into my laundry habits. But the important point is then made back in her third witness statement, dealing with Dr. O'Neill's criticism. Well, why haven't you taken the case specific? And she makes the point, it is not difficult, it is not easy to get specific data for bedroom usage. And this is 7 to 8 in her third witness statement. I'm sorry, I'm running between the two. Pages 123 and 124.
And let's just catch up with you. Pots 3, 1, 2, 3, paragraphs.
124. Yeah. Paragraphs 7 to 9. And you'll see her explanation. She says there are other ways the methodology could have considered occupancy and used finer grained data, but she then goes on to explain why that is difficult. Not least because water companies don't produce estimates on a per bedroom basis. She also makes it clear that the use of the average occupancy rate is a common factor when you're assessing environmental impacts, and that's explained in the same section of her evidence. And she explains why, when you add that to the other assumptions, which are there to generate a proxy for wastewater generation, you take the nonlinear relationship and the 100% new population assumption and the other point she mentions, it's best scientific evidence applying the correct approach, which is not absolute certainty. I'm going to come on briefly to a couple of the authorities in a moment, but it explains in a very careful and considered way that Natural England have been looking at this with significant care and detail for a number of years. And as the court will be aware, from the authorities dealing with the exercise of scientific and expert judgment, which this, in my respectful submission, is a paradigm example. If you have a clear explanation from the person that's produced the advice as to the basis of that advice, that adds, of course, to the issue. And merely because there is a dispute of expert evidence, and you'll see this from Mott and from my Lord the Senior President's judgment in BACI, from the Court of Appeal in Plan B, and the High Court indeed in the first instance case, all of which is in the bundle and referenced in the skeleton argument, even a dispute of expert evidence will not be resolved in favour of the claimant, providing the court is satisfied that the decision-making body, or in this case the producer of the advice, has acted using its own statutory expertise and discharging its own statutory role. In my respectful submission, as I say, this is an example of that, and this applies to all of the 3 grounds. When you come to look at the buffer, that is explained both in Mrs. Potts' second and third witness statements. It isn't a wet finger in the air, as my Lord pointed out earlier. It is based on an iterative process of looking at the research and looking at the various assumptions and the various uncertainties that are built into any assessment of housing. Because, as I've already said, you're dealing with the life of housing over a considerable period of time. Occupancy will change, habits will change. It's those residual uncertainties which leads to the application of the buffer. I'll come back to that specifically in a moment. But in our respectful submission, one needs to look even at the 2.4 in the context in which it is used, and it can't be looked at as a single component without then looking at the other factors that were considered alongside it. The Fareham specific average, the non-linear relationship of water usage to household numbers, the 100% precautionary new population assumption, all of which Natural England came to the conclusion gave a robust basis for its starting point. And it is only a starting point. And the court has seen already in section 4 how that's characterised by Natural England. If a local authority wishes to use bespoke calculations, it has to be able to justify them. And you'll find much the same in the new guidance. 2.4 is the default or the starting point, but is subject to, providing the evidence is robust and sufficiently certain, it's open to substitution in appropriate cases. But of course, one of the starting points in any catchment's consideration is how the national average will compare to the local average. There are other factors at play, and I won't go into the details with the references. You'll see them in that table I drew the court's attention to. But for example, occupancy rates are in decline, even for the larger properties. Mr. Justice Jay rejected that, which is why it's in the respondent's notice. This is a predictive exercise about future usage. It is entirely appropriate, in my respectful submission, contrary to Mr. Justice Jay, to take account of clear trends in occupancy, because that is relevant considering the uncertainties that exist over time. And there are other such factors in there. We've listed them in the respondent's notice. They're in Mrs. Potts' two main witness statements. And in my respectful submission, they all go to indicate a very careful, scientific and considered exercise of expert judgment over several years. The history of the matter is explained in more detail in Ms. Potts' second witness statement, paragraphs 10 to 17, which I'll just, for the court's reference, pages 162 to 164 of the supplementary bundle, and also in her first witness statement, paragraphs 8 to 11, pages 201 to 202 of the supplementary bundle.
I'm very sorry, I haven't been able to note those references.
I'm sorry, the history of the guidance. First witness statement, paragraphs 8 to 11, supplementary bundle 201 to 202, and second witness statement, paragraphs 10 to 17, supplementary bundle 162 to 164. And just for completeness, her emphasis on the holistic methodology issue in criticising Dr. O'Neill is in her third witness statement at paragraph 5, supplementary bundle, page 123. My lords, can I tie this in to the Dutch nitrogen case as well? If I could ask the court to go, I've got it in the second bundle, it's tab 37. Could I ask the court, since the court doesn't have the bundle page numbers, it's tab 37, it's page 596 of the report in the Advocate General's opinion. It's some of the passages my learned friend alighted upon yesterday.
So Advocate General at paragraphs
54 and 55, and then later, I'll just find it, at 146 on page 610. This is about averages and estimates. You'll see at 55, as my learned friend highlighted, not sufficient to show rough averages and to ignore local or temporary peak load values. But accepting at 54 the submission from Denmark that it is possible to rely on estimates as an appropriate assessment of the implications for the site is necessarily a forecast of future effects. So the fact that this is an estimating exercise is inevitable because you are judging future effects. And estimates are not ruled out. It's rough averages, or, as is said in 46, a mere average value. What you have here, however, is not a rough estimate or a mere average. You've got a very detailed methodology, which is explained both by the methodology itself and further explained by Mrs. Potts in her witness statements. This is an attempt to assist a local authority reaching a specific decision on a specific project. It's not, as the learned friend rightly pointed out, in Dutch nitrogen, the problem here was you had a national programme without specific assessment of individual projects within the programme. That was the difficulty. And indeed, if you want to see that set out clearly, you only have to look at the answers of the questions, the answers of the court to the questions referred on the last 2 pages, 641 and 642, to see that that was precisely the issue. So, my lords, the use of estimation is not of itself inimical to the operation of the appropriate assessment requirements. Lords, can I just then deal briefly with the role of Mrs. Potts' evidence? It is there as a response to the attack on the guidance in the claim form and then by Dr. O'Neill. And it, in my respectful submission, is a legitimate response and not an attempt to introduce ex post facto new matters which were not relevant at the time the advice was produced. And can I refer the court to my Lord, the Senior President's judgment in the BACI case at paragraph 89, where he commented to similar effect on the evidence from the Environment Agency in that case. Appreciate it was a different issue, it was an alleged error which had been transposed from the application forms. But it's the same point.
So which tab is that?
34. Thank you, 34.
24.
24.
Thank you.
It's paragraph 89, and it's page 468 of the internal report. It's not an Ermakov problem, in other words, if I could put it that way.
I think that this court also offered some guidance on this whole question in the judgment of the court in the taxi driver's case. Are you familiar with that?
Yes, I don't have it.
No. Bishopsgate. Anyway, I don't believe it says anything different from
my Lord,
from what was said in the ACI.
My Lords, I just make 2 points. Firstly, it's a legitimate explanation of how the policy was derived, and it's not based on trying to introduce new factors, but it's merely telling you what was behind Natural England's methodology at the time. And I just remind the court, of course, that it would, paraphrasing paragraph 47 in the A case in the Supreme Court, it would make it very unwieldy if all the elements had to be set out in detail, and it's not necessary to do that. If the court thinks that it would be helpful, of course, it's open to Natural England to revise its generic guidance to list out those factors in an appendix or such other matter to make it clear. But in my respectful submission, it's clear from the passages I've drawn the court's attention to this morning, and those that Mr. Moulds mentioned, that what Mrs. Potts says, as the joint head of the Solent neutrality team, is an explanation of how the advice note was produced. You're given the history and the justification for why those judgments were exercised, and dealing with Dr. O'Neill's response. The second basis on which that evidence is justified, in my respectful submission, is simply in response to the grounds of challenge that were put in the High Court. We are entitled to explain why it wasn't an irrational decision, again, by reference to evidence as to what was in the mind of Natural England collectively when the advice was produced. It is not Ermakov post-decision elaboration in the sense of introducing new factors, but merely explanation of what was decided at the time. And my lords, the fact that the guidance that you now see, having been promulgated last month, follows a similar line, though not identical, in my respectful submission, is also supportive of that. My lord, turning back to Dutch nitrogen and the general points made by my learned friend, I agree, as I've already said, with my learned friend, Mr Mould, as to the specifics of that case, and I've already mentioned that. As for paragraph 101, seem a little bit like room 101. Firstly, I'm not aware of it having been considered, other than by Mr Justice Jay, in domestic decisions. Secondly, the context that Mr Mould and I have explained is significant. And thirdly, 101, properly read, is telling the court to scrutinise the assessment carried out by the competent authority, which is nothing new. In other words, the court is reviewing whether or not the competent authority has assessed the potential impacts in the light of the guidance of the court, requiring sufficient certainty, etc. It's clear, only if the national court is satisfied that the assessment carried out in advance meets those requirements in respect of each individual project. And of course that was emphasised, precisely the reason Mr Mould indicated. You had a programmatic attempt to avoid individual assessments. And I gave through Mr Mould the paragraphs on certainty at paragraphs 126 to 130. Again, that was in the same context at page 639 of the report. That was in the context of the fact that this was an attempt to avoid individual project assessment, so the measures to be taken in individual cases were necessarily unknown at that time. In this case, that the purpose of the exercise advocated by the methodology in the advice is to lead to a requirement for mitigation for the individual project, which will be secured by planning condition and or planning obligation, so that the properties cannot be occupied and the effects cannot take place until the mitigation is in place. So this completely lacks the characteristic of uncertainty which was directed to the attempt to exempt projects generically by the Dutch authorities in that case. I need to deal briefly with what my learned friend said about worst case and the precautionary principle. Lords, I've already shown your lordships and referred briefly to Mrs Potts' evidence that a significant degree of the approach and the methodology assumes worst case in this case, the 100% occupancy, the wastewater treatment works being at 90% capacity, etc. The attempt to bring in the Commission's guidance, which you saw at tab 41 on risk assessment, goes nowhere. This was considered by Advocate General Cocotte in the Wadensee case. I'm going to take you to the paragraphs in a moment. This is already incorporated into the court's test for appropriate assessment. That is to say, the certainty requirement and the approach to appropriate assessments which require that they are specific, precise, don't contain lacunae, etc. That is all based on an embodiment of the precautionary principle. To do what Mr Jones is doing is double counting. The methodology is intended to give effect to the high test imposed by the European Court. If the court would please pick up the Wadensee case, which is in second bundle at tab 37.
I think it is.
Oh, yes.
Page 708 of the internal report reference.
No, I think you're somewhere else.
Am I adrift?
Dutch nitrates is the...
Sorry, it's Wadensee.
Wadensee is which?
32.
32. Mercifully in the same folder.
Yes. Page 708, which is headed taking account of the precautionary principle and permissible doubts as regards authorisation. And in a series of paragraphs which I'm not going to read out, I'm sure unnecessary to do so. Down to 107. 107 is the paragraph which Lord Carnworth cites with approval in Champion that says absolute certainty isn't required, nor would it be achievable. But if the court would read the preceding paragraphs, the Advocate General explains how and that the rule applied by the court, the principle applied by the court, incorporates it. You'll see it at AG 100. This rule gives concrete expression to the precautionary principle. The decisive factor, she says it halfway down the paragraph, is the element of scientific uncertainty as the risks involved. Now, in a freestanding precautionary approach, of course, you're assessing the level of risk against the value of the interest which is being harmed or may be harmed by the risk and the extent of that risk. What the Advocate General goes on to say at 101 and 102, that Article 6.3 does that exercise. That is to say, it constitutes such a rule. That is to say, a rule which decides what the acceptable level of risk is for protected sites under the Habitats Directive. So AG 101 and 102 makes it clear that risk balance has already been discharged by the legal principle in Article 6.3. So there is no need and no justification for trying to apply it again, providing the proper legal test is being applied. And she says at 103, and this is echoed in numerous court decisions from Vadensee onwards, the authorisation threshold, etc., is capable of preventing adverse effects on sites. No less stringent means of attaining this objective with comparable certainty is evident. There could be doubts only as regards the relationship between the authorisation threshold and the protection of the site, which can be achieved thereby. And you have that reflected when you get to the judgment of the court at page 7 to 8, paragraphs 58 and 59. You were shown this yesterday. But you'll see at 58, the court specifically says, it is clear that the authorisation criterion integrates the precautionary principle. So it's the legal test through interpretation of Article 6.3 which achieves compliance with the principle. There's no freestanding separate application that then falls to be applied if you're satisfied that you've reached the requisite level of certainty. And that you'll see repeated in numerous cases, and I'm not going to go to them, but see, for example, Sweetman, which is at tab 38, paragraphs 40 to 41 of the court's judgment, internal page 1118.
Sorry, which paragraph?
40 to 41 in the court's judgment.
Thank you.
And in Dutch nitrogen itself, paragraphs 98 to 100 in the judgment of the court, which is in the internal pages 634 to 635. So it is clear, therefore, that the precautionary principle is embodied in the legal test, and if the local authority applies the guidance in 419, it is applying the approach which is an accurate statement of the law so far as appropriate assessment is concerned. And in any event, it is not inevitably leading it into error so as to satisfy the requirements in A. Lords, that deals with my general submissions and with regard to the role of 2.4 and the average occupancy rate within the context of the methodology. I'm going to deal more briefly, and I've only got 9 minutes, with the two other issues, that is the advice on existing land use and its contribution, and the buffer. And these are, again, explained partly by the guidance, and the background to it is explained by Mrs. Potts in her two witness statements. Sorry. Oh. Looking at the wrong bundle, and I've got it open in front of me, sorry. The use of the farm scoper averages is there to help ascertain the answer to the question, what is the site already permitted to discharge, or what does it discharge or likely to discharge? Because, of course, it's relevant if you're considering whether you're increasing the nutrient burden in the protected waters to consider whether the site is already contributing to it. The average figures are there to help the authority. They are based on commissioned work from ADAS. You'll see that at 446 and 447. And they are to be regularly updated. And I think they were updated for the latest guidance, but that doesn't really matter. The point is that it's intended to be precautionary. And at 451, it is recommended evidence is provided of the farm type for the last 10 years in professional judgment as to what the land would revert to in the absence of a planning application. In other words, it is for the competent authority, which is the planning authority, which is best placed to understand the current use of the land which is being proposed for development, whether or not there is an existing permitted use and whether it's likely to make a realistic contribution to the nutrients in the protected waters. And it may be the case that it does, it may be the case that it doesn't. This is intended to be an assistive tool, not a prescriptive approach. And there's no evidence in my respectful submission that it's said to be so. For example, it says there are many areas of greenfield development that are not currently in agricultural use and have not been in such use for the last 10 years. So you assume a minimal input that you'd have from a green space. And indeed, I think that was done in one of the instances here. Mrs. Potts explains this usage, and you'll find it in her second witness statement. I'll just give you the references. Paragraphs 45 to 49, pages 173 to 174 of the supplementary bundle, and in her response to Dr. O'Neill, paragraph 14 to 15 of witness statement 3, pages 126 to 127. And you'll see what she says is why you take a wider approach. It's to avoid what she calls gaming the system. In other words, getting a snapshot which may be very favourable to the applicant, but which is not representative of the contribution the site may make to nutrients already going into the protected waters. So hence the reference to a suggested 10-year period, so that you're looking at a broader issue, and you don't suddenly have a developer who sets up an agricultural operation on the site to intensify nutrient discharge to assist the development, which is then put into application form a year or two later. It's there to stop precisely the sort of gaming of the system which could occur. And she explains that and why Dr. O'Neill gets it wrong in those two paragraphs. I don't propose to say anything more than that. With regard to the buffer, as I've already said, it's not a wet finger in the air. It is there to deal with residual uncertainty which inevitably arises because of the nature of the development. If you're building houses which can be occupied for up to and over a century, you need to make sure you've taken into account the fluctuations over time. She deals with this in paragraphs 54 to 64 of her second witness statement, pages 176 to 178 of the supplementary bundle, and in her response to Dr. O'Neill in her third witness statement, paragraphs 16 to 22, pages 127 to 130. In fact, at 22, she comes back again to the holistic methodology point. But you will see an explanation. For example, paragraph 18, She says, Dr. O'Neill's assertion temporary long-term exceedances have not been factored in is incorrect. The potential for exceedances to occur has been considered and factored into the buffer, and she raises various points that he hasn't factored in, such as the treatment works being 25% below the permit level, etc. So 20% takes those into account, and she explains at 19, the development of the buffer has involved consideration of the likelihood, severity, duration, and tendency of potential impact. In determining the level of the buffer, each component was assessed individually, as well as evaluating the relationship between each component, the risk of exceedances, and the severity of such exceedance. A stepwise and iterative process has been taken. This assessment has considered the degree of known variability for each component, as well as external factors, and taken into account the fact that not all the risks are fully known. So, Lord, it's a very clear explanation that this hasn't just been done on the back of a fact package. It has been done carefully and working through the various potential for exceedances and ensuring that the 20% covers that. This is the exercise of expert judgment by the expert body dealing with nature conservation and biodiversity, operating through a team which is specifically dealing with the issue of nutrient neutrality. You see that from Mrs. Potts' witness statement. So in my respectful submission, the characterisation of the buffer has been grossly misstated by my learned friend. It is a careful and considered result, and it is applied at the end of the exercise. It's not my role to deal with robbing Peter to pay Paul issues. You see in the way it's worked through that it's applied at the last stage to cater for residual uncertainties, as explained by Mrs. Potts. Lords, those are my submissions, and I think I'm within my time. But if there's anything else I can assist the court with.
No, thank you very much.
On the floor. Thank you.
Yes, Mr. Jones, you're a client.
Well, Lords, first can I deal with the question of Dutch nitrogen case? I just need to give some references. Mr. Mould submitted yesterday, it was adopted by Mr. Elvin today, that the paragraph 101, Dutch nitrogens, I apologise for my voice, is a result of scepticism about programmatic approach. That's frankly a nonsense. Paragraph 104 and the head note that you were asked to look at, the court expressly found that programmatic approaches were entirely compatible. The issue is the approach that is taken to appropriate assessment and ensuring compliance. So it's a false distinction to make that the court's direction, which required, and the courts do not say, a review of a competent authority to see that it's thorough and in-depth. It is the role of the court, and that is something your lordships will need to grapple with. I don't think I need to go that far in this case. I'll come on to it. Second point is Batchy tab, if I pronounced it correctly, tab 24, page 471, para 100, which I think you were taken to 99 but not 100. But if your lordships briefly go, if you may, to tab 24 and paragraph 100. This is applying Wensbury, invoking that principle to excuse a patent mistake of fact or basic science would of course be misguided. And however Natural England is dressed up, and I'll come on to it in a moment, we are not dealing with logarithmic science. This is pretty basic stuff. And that is entirely within this court's jurisdiction without us getting and worrying ourselves. But I don't resile from the fact that the application in this case of Wednesbury must always be in the statutory context. Now, I've been subject to looking at my pleadings, and when I'm kept to the pleadings, I mean, to be fair, and as the judge noticed, the case that I'm meeting each time changes. Mr. Elvin now, and I won't take your lordship to the references, are very happy with it. The dispute between us below on worst case scenario was whether it applied to the precautionary principle in the Habitats Directive. Plainly it does, and it is built in. Mr. Elvin now makes another point. Frankly, I don't understand it. Doesn't matter. The point is, we relied on it. When you are looking at Regulation 63 and the precautionary principle, you understand it in the terms of what is precautionary, worst case scenario. And that brings me on to the statutory provision that we have. And in answer to my Lord Justice Nail's question, it's the ex parte Balchin point that my Lord Justice Singh raised. This is a decision that simply doesn't add up. So let's take it in stages. In answer to questions from my Lord Justice Mr. Mould rightly conceded that if the officer had recommended 3.1 or 3.0, that would be Wednesbury reasonable, within a range of what he says are Wednesbury reasonable decisions. But plainly, if that's the matter, that is not the most precautionary approach. Because we know, and this is before we get on to the misapplication of the buffer, and Mr. Elvin was quite frank, it's fair, the guidance is intended for the buffer at the end. And I'm being told it's holistic guidance and that it all works together, but now we know, and it wasn't the case below, but now Mr. Mould makes the case that it was all right for the officer, and there's no evidence of consultation with Natural England about that, to actually misapply the guidance. Because as Mr. Elvin made clear in the last submission, and I agree with him, it is intended to be quite separate, and that's evident from the wording of the guidance. So if you have that, and you ask, let's apply the 20% buffer to whether you go 2.4, because as my Lord Justice Mail said, you're right on the cusp. We're supposed to be precautionary, even under this system. On 2.4, it just gets through. If you apply 20% buffer, you apply the whole of that 20% buffer, and you'll see, as we saw, reliance is put on the 20% buffer there. That makes little or no difference to your 2.4. When you plug in the figures, the buffer of 20% on 2.4 comes nowhere near 3 or 3.1. So put those figures, the buffer does nothing in that dispute. And so the point then applying Wednesbury is if you're applying the precautionary approach, you then look, and it's accepted, and it must be accepted, that the evidence, and this is a claimant's you're damned if you do and you're damned if you don't in planning judicial review. If you put forward the evidence, it's then said, oh, of course, the local authority took it into account. If you don't put forward the evidence and you raise it later, you said, oh, you never put it forward. Here, my clients put forward evidence which is not disputed as being statistically accurate on what is the local requirement. And my learned friend, Mr. Elvin, and I just give you the references, but I would ask your lordship to read now the new guidance, which is said, advising all these local authorities now, at this moment, will be making planning decisions based on this guidance. Stage 1, calculation nutrient loading from additional waste. Selecting a robust occupancy figure.
Sorry, if you want us to read something, what is the document you want us to read?
It's the additional documents put in by Mr. Elvin.
Yes.
There's no reference to it. I put them in a separate...
Unfortunately, mine are not paginated or even organised in any way I can understand.
With respect to... Well, I didn't put them in, my lord, but...
which of the various...
It's repeated both in the general guidance.
Neutrality generic methodology?
Correct, my lord. And if
Okay.
you go through to stage 1, which is there are, maybe a recommendation, a neutral recommendation you can give to National England to put page numbers on, would be page 6, I think, stage 1, calculate loading from additional wastewater. So there's been no. Just very quickly, I'll ask your lordships if you would to read it, but I just highlight how selecting a robust occupancy figure, competent authorities must satisfy the residents doing value use reflects local conditions in the area. The residence per dwelling value can be derived from national providing it reflects local conditions. Precisely what my clients did. However, if it does not yield residence per dwelling that reflects local local relevant data should be used instead. Whatever is got to be sufficiently recommended. Now, this is precisely what my clients did. It's precisely right, of course, because a national average, unless you have no other evidence, is absurd. You only have to do the calculations. Mr. Mould comes forward and then says, oh, well, yeah, you might have bigger, you might have smaller. No evidence. And this is across the whole of the United Kingdom. We are supposed to be looking and protecting and applying precautionary principle to particular areas that are failing. They're failing now, and they're continuing to fail. I'll come on later to what Mr. Elvin says about where he has his apples and pears, as I call them, where the holistic thing, you're looking at 110 litres, and how well the assumptions are of wastewater treatment plants. I'll come on to why that's irrelevant in defence of the grounds in a moment. But I do note in passing, it is obvious that whatever the wastewater treatment plants are doing in the Solent, they're not working. And we have that on Natural England's advice note. We have failing and we have continuing failing on the species. So if your lordships are being given comfort on that, it's very much cold comfort. But also that's the approach that needs to be taken. On the position that Natural England took, contrary to what Mr. Mould now submits, and I ask your lordship to look at it, but consistent with the guidance, Natural England's officers, they are hard pressed, they don't go to the sites, they follow, that's why we have the guidance. The officer in those emails expressed no view on occupancy. It is completely unclear whether she saw the officer's report as to why he, misapplying Natural England's advice, was relying on the 20% buffer. There's no evidence. So Mr. Mould's submission, elegantly put as he always puts his submissions, is completely without foundation of the evidence before your lordships as to what was in front of the committee in the involvement. And it's contrary to the advice that Natural England give. I've given the references to your lordship, your lordships in my opening. I won't give it again, but it is made clear that responsibility, even in the original guidance that we're looking at, was on the competent authority to make the assessment on whether bespoke housing or not bespoke. Now, we've heard a lot about the judgment of Natural England and their expertise, but they weren't making the judgment in this case as to whether the occupancy rate should be taken or not. It was a planning officer. Okay, so we hear a lot about Miss Potts and all of those things, but the guidance made very clear that the starting point was the national occupancy, but it's a planning officer at Fareham who makes the decision based on the reasons that he gives. First reason, not in the guidance. We still don't know how he come upon it. We then have the speculation that because, and then we hear from Mr. Mould, speculation that, oh, of course, it's overestimate by how much we don't know because it's uncertain, according to Miss Potts, that we have people from Fareham who might be living with their parents. So they then moved. Adults. Okay, well, if we're going to speculate, we can all speculate. Those of us who do planning know of these trapped communities. One reason population decline of younger people is because adults living with their parents cannot then have families until they move to bigger houses. It's an issue in the Midlands with various communities that do like to live together. So the opportunity to move to bigger houses is not going to be the parent, insofar, this is all speculation, but this is all the uncertainty, is for the younger people who will fill it up and have kids. That's the point of moving from living with your parents to a 5-bedroom house. Is it going to be the parents moving from the house that Mr Moulding introduced to the 5-bedroom? Pretty unlikely. So, but in any event, none of this is quantified. This does not then deal with the fact that you randomly use, I think it's the UK or GB's occupancy for all sizes of houses, without reference to the type of place, Fareham, Southampton, the types of houses that are there. There's also the other issue, of course, both guidances in different ways make it clear that it is open to an authority to take a bespoke value. So if Mr Elvin's submissions are right, and it's very difficult to keep up with them, but if you are right, and all his apples and pears of comparing them, they're all holistic, you can't pick it open, then when would you ever use bespoke? You would never use bespoke because you'd upset all the apples and pears and you'd lose your appeal, which is always held out as a threat, that you'd lose your appeal. So it looks like the only one-way street that goes with this local authority is that they were prepared to go lower, but not higher than the average. Now, when you come to look at it, my lords, and I ask you to look at it, the new guidance draws attention to the problems with doing what Fareham did and are doing, which is dipping in, and when it's lower, taking a lower one, and then when it's higher, going to national average. Because you do that, and you're messing up the national averages that you're relying on. Because, again, I wouldn't say it's robbing Peter to pay Paul. So that is deeply flawed. So one starts on just rationality. On what rational basis, when you are faced with the crisis that is facing the Solent in terms of unrecovering environment, and the fact that you are, you've got to be absolutely, not absolutely sure, certain, but you've got to be beyond all reasonable scientific doubt. So the guidance makes very clear you don't pick them up separately. And that's clear in the evidence of Mr. Elvin. I don't need to address that because very fairly Mr. Elvin made that clear. But that is what this authority did. When they were presented with better local evidence taken from the ONS, what did he say? He said two things. One, a point that was never in the guidance, and which, if it was, we would have had an opportunity to challenge, which is an unspecified claim now by Miss Potts that it's so uncertain that we may have over-provided by taking a national average. And secondly, dipping into the 20%. Now, first of all, 20% is contrary to the guidance. And if you see under the statutory provisions we've just been shown, Natural England, if its advice isn't being followed, which isn't being followed, have the right to then ask for detailed reasons as to why it was not being followed. Hasn't happened in this case, not part of our case, but I just note that, and you'll see that in the statutory provisions that you've been given by Mr. Elvin. Second point is, of course, whilst not involving you in any deep science but simple maths, 20% is no buffer between, if he's saying he may have 2.4 wrong, and it may be 3 and it may be 3.1, but don't worry, I'm going to apply the 20% buffer. 20% buffer doesn't get you anywhere near what a 3 or 3.1. Because when you work through the calculations, it comes out much more. So there is no evidence before the committee to gainsay that on the evidence before them, in fact, 3.1 was the best scientific evidence. Ex post facto, we've actually gone further and refined it to 3.0. So it's for the right size houses in the right location based on national averages over 10 years. Now, the only reason that they say 10 years is right is because the national average has some standing is because it's been done for at least a 10-year period. The ONS figures, it's not a snapshot. Well, that's the only thing that's in its favour. In terms of you take from the same set of figures, the average for the right house and the right location, you've got that 10 years security as well.
It is a snapshot, isn't it? It's taken from the 2011 census.
Yes, it is, but it's based.
So it's a snapshot of the position on one particular day, in fact.
Yes, but what is said in the Natural England guidance is because these censuses have been carried over a 10-year period. That's what the guidance refers. All I'm saying is there's no difference between the ONS figures for the average of the average house and the average that was used by my clients. On that point, there is no difference for whatever it is. So, my lord, if you're taking then the precautionary principle, and as the case law also demonstrates, where you're in a failing situation, there is no rational basis in my submission for why the committee could take the view that it would apply to what were going to be 4 or 5 bedroom houses, a national average. We've had ex post facto talk about the linear thing that I'm not going to get into. Certainly, when my children come back, the washing goes massively up in the house. Although the occupancy rate does have an impact on it. Not get into any of that. That's a refinement on something which is accepted, that higher houses will have bigger occupancies. And so there will be a greater production of nutrients. Whether it goes up in a logarithmic, flat curve or whatever is nowhere near here, because we're right on the cusp with 2.4. So, and we're supposed to be being precautionary. So that's the difference when you bring in precautionary to Wednesbury. You could have the range of figures, which ordinarily would be okay for a decision maker. But when you have to choose the most precautionary, Wednesbury says it's acting irrationally if you take a figure which, based on the evidence, isn't the most apposite for the area. So the links then that I moved from ground 1 quickly to grounds 2 and 3. In terms of, yes, as we've always said, it's insofar as there's reliance on land uses and averages, we stand by what we say. The Dutch nitrogen case does not endorse, whilst you have to make predictions, it doesn't endorse, contrary to what Mr. Elvin said, predictions where you anticipate a falling off or that things would get better. And the reference for that is Dutch dikes, not Dutch dikes, it's Dutch nitrogen, para 94 of the Advocate General's opinion 1137, where it specifically says you may be anticipating things would get better, or the capacities get better, or the machines get better at sewage treatment, or that people don't have so many children, or whatever, washing machines get better. You can't do that. So yes, you can make predictions, but it's a type of predictions you make. And 94, which Mr. Elvin didn't go to, is the one that deals with the point he was trying to make. My lords, then on terms of the planning policy, I think I've been scolded by saying that this case has matters of general importance. That's been scolded or teased in terms of the nitrates case. And certainly if you look at Mr. Elvin's LinkedIn, you'll see how many followers and things he's got in his discussions about it. But on ground 4, it's equally important for planning. For this reason, I take the starting point is this. First point is the interpretation of planning policy is a matter for the court. The reason we have a development plan system, and this, if Mr Wyatt is very astute for me to make sure I spend time on this point, and I can understand why. Participating through the local plan system, which is currently going on now for the new plan, people have an involvement, and wording, as my Lord President will know, is a matter of which the inspector, in finding the plan sound, and which people representing spend a lot of time on getting the wording right. And so that, when we come then to the application and the two-stage test, first of all, can we have a look at the, it's easiest if you take up the two pieces that I have with the policy. There is no policy that my learned friend points to on this issue which supports this development. So the only policy is DSP 40, the exceptions policy. Comes to that in a moment. So the starting point, this is not a case where there are policies pulling in separate directions. For example, we need to encourage renewables. We don't want ugly things in areas of outstanding natural beauty. You've got wind farm or solar in the middle, where they pull in opposite directions. That's not this case. So we come to development outside settlements, and CS14, and can I just go back? The starting point is why development outside settlements have been regarded in the countryside, that's what it means, in the countryside, outside, and it's largely acknowledged by Mr Mould. They'll be strictly controlled to protect the countryside and coastline from development, adversely affect its landscape, character, appearance and function. Function is the last one on sustainability. So the plan says development outside will be strictly controlled. And it's to protect the countryside for landscape, character and appearance. And we know, and the officers, and you'll see in the report, found that this would have an adverse impact on landscape appearance. We go to DSP 40, and then the fact is the policy, which is an exception to those that are allocated, may be permitted, it's not will be permitted, where you haven't got 5 years, may be where they meet all of the following criteria. Now, part 2 is expressed to have more than one aspect. It doesn't matter that those aspects fall in Roman 2 and have the word and, or if they were split and it became a third criteria. So the judgment was that there was a breach. It wasn't a breach in terms of sustainably located, but it wasn't well related to existing urban settlement boundaries. And that brings into play the other reasons why there is in CS14 a policy presumption against. So the position is, as a matter of law, based on that planning judgment. Now, if the planning judgment had been that it was adjacent to an existing urban settlement boundary, then we'd have, and there is case law actually in others, this is what I mean by adjacent, but that would be a different story. I don't have to get over that hurdle. We have the finding of fact that it is not. So we have the finding of fact, and one has to think, if you're advising a client, do you meet these criteria? And you were writing an opinion for your developer client, you would say you fail criteria 2. The consequence of that is you fail policy DSP 40. So we take the step back. That's all law. But I'm being told that it's open for the officer to advise members that overall it's in compliance with the plan. That is a straight error of law. and the difference is material, and it is not being argued that there's a discretion in this case, nor could it, that means you have the statutory presumption in favour of the development being granted consent, as opposed to the correct position, which is effectively a statutory presumption against, unless other material considerations indicate otherwise. So you would then be weighing up. So what you'd be saying, this isn't this case, but it'd be slightly bizarre, but you'd be saying a policy which, as Mr Mould rightly says, local authorities want to control the release. They don't, when they have a non-5-year supply of housing, want to leave it to the Wild West, or planning inspectors. I don't mean they're the Wild West, but leave it to with no guidance. So what they're doing, precisely as Mr Mould says, is setting out strict criteria to control it. So here we would have, you're against those criteria. It doesn't matter, as I said below, it's like, you know, they say about being pregnant. It's not something that will happen to me, hopefully. I'm too old. But you can't be a little bit. You're either in or out of the policy. And being out, the statutory presumption, and then you would have to, what is there in favour? It's all the other criteria that it met. Well, this isn't this case, and in fairness, Mr Mould is not saying that if he doesn't get home on that, the decision would have been the same, inevitably, if it not been the case. So we say it's a pretty clear case. Why do I say it's more important? If this court endorses this approach, you will have advocates, I will be one of the ones, and others, going to clients and say, well, it doesn't matter actually that we don't meet that criteria or that criteria, because you can take an overall view on precisely this type of policy, an exceptions policy, that you don't have to meet all the criteria, even though it says it does, because as a matter of planning judgment, you can find lawful compliance with a policy contrary to its wording as a matter of planning judgment. Consequences would be quite significant. So, although the judge eventually ruled against us, you could see the difficulty he has had. If you go through my learned friend's pleadings, you can see the difficulty my learned friend has had in changing the case, although he says he hasn't. I'm with the judge, and I suggested with the judge in as far as the case has changed. And that reflects, if the case has changed for my learned friend, how can we even be sure that the members knew what was being told? But if it is, as now is being said, that it's a finding of compliance with the plan, that is an error of law. My lords, unless I can assist any further, that's 1 o'clock.
Thank you so much, Mr. Jones.
Yeah.
Yes, thank you. We have no questions. Thank you. Thank you all very much, all of you, for your careful written and oral submissions. Judgment will be reserved and handed down in due course in the normal way. A draft of the judgment or judgments will be circulated to the parties for typographical and minor factual corrections only. We shall expect a draft order and any related submissions to be provided to the court in advance of hand down in the normal way. Thank you all very much.
Thank you.